Hi everyone, my name is Lujain Abbas. I am an advocate of the High Court of Kenya. I currently practice corporate law with a focus on corporate finance and technology law. I act in the capacity of Legal and Compliance Counsel at Lami Technologies Limited, a technology company based in Kenya. For today's session, I will be taking us through content management and the law, what exactly is required of you as a developer when you're coming up with content management systems, and what you need to consider around your contractual obligations. So throughout my presentation, I will be looking at the brief description of content management and what legal would be looking at in terms of what we would define content management as. I will also be looking at two focal areas, your contractual requirements and regulatory requirements. I will also be considering the gray areas in content management and perhaps give a conclusion on what I think of the entire industry. So throughout my presentation, I will be making references to a number of laws which relate to this particular thematic area. I will be using these laws as a general guideline, and if you should require any sort of specific legal advice, then you should be in touch with lawyers within your particular jurisdictions. So the laws in question would be the Copyright Act of 2001, the Trademarks Act Cap 506, the Data Protection Act number 24 of 2019, as well as the GDPR. So with that disclaimer, let's jump into what are the contractual issues that we would be considering throughout software and web development. The first thing that any client would be looking at when they're considering a content management system is to first find a specialist who is going to take them through how to build this particular system and how it's going to run, depending on the specifications that they have given to them. So having that in mind, the next thing that you have to consider is an agreement, which is basically the most important element of this particular transaction. Not just finding a specialist, but finding an agreement that caters to both your needs and the developer's needs. The agreement that we would be looking at, or rather the agreements that we would be considering, are dependent on the nature and the business of the particular developer in this particular transaction. So if you're a freelancer or an agency, we would be looking at a software development agreement or a web development agreement in the instances of a website. And if you're an in-house developer where you're working with big law, you would be looking at an employment agreement which sets out your job description as well as the particular clauses that I will be considering in a moment's time. Okay. So a software development agreement or a web development agreement is basically an agreement that sets out the terms in which a developer will sell and transfer their customized software to a client, and the client in that instance would use this particular software and incorporate them into their products, their processes, or services that they may be interested in. Other than the agreement in question, there is a scope of work, or something also known as a statement of work. A statement of work is essentially an appendix that is attached to the software development agreement, and it just sets out the requirements of the software on a more technical basis. I will not consider every clause in these particular agreements because they're very technical in nature and commercial, and it's usually customized depending on the commercial transaction and the needs of the parties. However, I will be looking at two clauses that should always be considered throughout your negotiations. So the first clause that we will be considering is intellectual property rights. So when we're dealing with web development and intellectual property, certain rights arise throughout this particular arrangement. So the rights could be in the software, they could be in the branding, or they could be in the domain name that is likely to be registered. So as a result of the different categories of rights that exist in web development, it becomes very important for you as a developer to be aware of this particular intellectual property rights so that you are able to mitigate any sort of dispute that may come up when you're dealing with your client. So let's just jump right into the intellectual property rights that we will consider throughout this particular session. We will be looking at copyright and we will be looking at trademark. So copyright is defined as a right that is granted to a creator of original work for the exclusive use and distribution of that particular work. So when we're looking at protection of, when you're looking at copyright protection, you would be looking at the original expression of the idea in tangible form. So if you're just expressing an idea, it's just in your head, there is no way you're going to get copyright protection. You have to reduce it into tangible form. So what does this mean in terms of web development and software development? It means when you develop your software and document it, then it is valid for copyright registration and protection. When you're looking at the Kenyan case, we would be looking at copyright in relation to software as a literary work, as provided for in Section 22 of the Copyright Act. The next right that we will be considering is a trademark. A trademark is defined as a sign which serves to distinguish the products or services offered by company A from those offered by company B. The sign can take, or rather consist of, letters, numbers, and incorporation of many other elements such as their names or the signatures or a combination of colors. And that would definitely amount to a trademark. So the right is governed by the Trademarks Act in Kenya, but I'm pretty sure the same exists in your jurisdiction. So when we're looking at web pages, would we be considering whether they have trademark protection or not? So as mentioned, we would go back to the purpose of trademark, which is essentially to distinguish the products and services offered by company A from those offered by company B. When we look at the example on the slide, we will look at two logos. We have the Lamy logo, which is my company, and we have a more popular one, the Adidas logo. When you look at these two particular trademarks, you notice that they are very different, which then leads us to the requirement of trademark. The first thing is that the mark has to be very distinct. Remember, you want to distinguish yourself from the industry players. The next is that the mark is not likely to cause confusion. So if the marks are similar, then there's no way you're going to get trademark protection. And then the third requirement that is needed to satisfy trademark protection would be, is the mark similar to another mark that has been previously registered? So when we're looking at web pages, we can conclude that trademark protection cannot be extended to them because a web page has too much information that changes with the need of the business, which derogates from the essential requirement of trademark, which is distinctiveness of the mark. However, when we're looking at the domain name, things start to change. For example, the word Lamy in lamy.world can be protected under trademark because the corporate company has decided to use their name as a distinguishing factor. So when you're negotiating your software development agreements or your website development agreements, there are certain IP questions that you have to consider. And one of those questions is, what is the relationship between the developer and the client? Are they in-house, or are they a freelance, or are they working for an agency? The general rule in copyright is that the author of the copyright will be the first owner. However, there are exceptions to this case, and the exception being whether the developer is working in-house. So if you're a developer working in-house for big tech, if you're working for Google or if you're working for Facebook and you're supposed to come up with a new website for them, the governing agreement in that scenario would be your employment agreement, which sets out your job description, that you'll be the one in charge of coming up with websites or the designs of the mobile application. And further, it would state that the intellectual property rights that would be existing within the works that you've created would vest with your employer. However, we see a different treatment when it comes to freelance developers or those that work with an agency, because the governing general rule is that the author of the copyright is the first owner, right? So if you're working for an agency or if you're doing this freelance, then the governing agreement would be the software development agreement, which sets out that unless there is another signed existing agreement that transfers or assigns the intellectual property to your client, the intellectual property would remain with you because you're the author. However, sometimes the assignment clauses can be included into the software development agreements to save on time and to save on legal fees. So when determining the scope of intellectual property, so basically you're trying to figure out whether your software is worth more than what the client thinks, there are certain questions that you have to consider. I won't go through all of them, but you'll have the slides with you. So the first question is the software running the website generic, or is it bespoke, where you're adding some certain elements that would not have existed in the first place? The other question is, would you want your clients to have the ability to maintain, develop, alter, or upgrade the website in future without having to pay another developer to do so? The answers to these particular questions will help you determine whether you require a full assignment of your intellectual property or whether you would need to license your intellectual property. So when it comes to bespoke software, where there's some sort of proprietary, element to it, where it's worth more being with you, then a license would be something that you would consider. So in that scenario, you would have to consider whether the license is exclusive or non-exclusive. So what do I mean by exclusive or non-exclusive? Exclusive means it would be for that particular client and for that particular need. Non-exclusive would be you opening it up to other clients. The second question to consider when you're dealing with intellectual property is what happens in the scenario where a developer uses a third-party software in the development of the website or the mobile application. Remember, you've already ascertained that there's some kind of software, there's some kind of intellectual property that sits with you. So if you've used third-party software, it means that you can't have the right to give a full assignment or an exclusive license to your client. You can only give them to the extent that the previous license agreement has given to you. So the next part of my discussion would be dealing with data protection and web development. So with the enactment of the Kenyan Data Protection Act for those in Kenya and the incorporation and acceptance of the GDPR in the global scene, we're noticing that there is a shift of how businesses now do business, because you have to take into consideration the importance of your consumers' right to privacy. You just don't have a blasé right to use the data that they've given to you. So as a result of this, there are a lot of words that keep popping up throughout the discussion. There's data privacy, there's data protection, there's a data controller, a data processor, data subject. So it's a lot of legal jargon going around, but in a bid to help and demystify this particular terms, I will go ahead to first deal with them and then deal with how they are incorporated into web and software development. So when we're looking at data privacy, we would be defining this term as a guideline for how data is collected and handled depending on its sensitivity and importance. So for example, if you're a startup or if you're a company, a scale-up in the healthcare industry, the data that you're dealing with is highly sensitive. So you have to be aware of it and ensure that you put in place the right measures to protect it. And that's what data privacy is about. It's realizing this. Data protection, on the other hand, is the set of tools, policies, and processes that actually restrict access to that particular data in order to maintain its confidentiality, integrity, and availability. So what we're seeing is that data privacy is how you're doing it. Data protection is what you need to put in place in order to achieve this particular regulatory requirement. So when we're looking at data protection and web development, I will look at first how data protection is included into your contracts, because a good software development contract is now taking into consideration the change in the regulatory space and including a data protection clause that stipulates whether there is a test data that is going to be used there, how the parties are going to be relating with it, because for every software developed, there has to be some kind of data that is used to help it run. The next would be looking at the regulatory requirements, so essentially what you need to put in place throughout the designing and the development of your system. So when we're looking at the data protection clause, like I mentioned, we are aware that for the system to work, there has to be some data that flows into it. So it is for this particular reason that this particular clause would place some obligations on the developer to ensure that they are compliant with the data protection laws. And these compliance requirements are what I'm going to discuss. So the data protection clause ideally would set out the following obligations. So it would talk about the data controllers and processors implementing technical and organizational measures in a bid to safeguard the data subject's rights. It would also specify that you need to acquire the necessary consents in order to process this particular data. It will also go ahead and mention that you have to ensure that the processing, the storage, and also any sort of transfer that might be needed is done in conformity, strict conformity with the data protection laws. So from these obligations, there are three things that come up. We look at data protection by design or privacy by design. We see that the consent of the data subject becomes a key proponent of the whole transaction. And then there's also the concept of who becomes the data controller and then who becomes the data processor and what are their obligations. So when we're looking at data protection by design or privacy by design, as the Americans would call it, this obligation is set out not only in the Kenya Data Protection Act, but it's also something that has been enshrined in the GDPR, which is the global acceptance of data protection laws. So data protection by design is a legal requirement that obligates developers to embed data protection in every step of the design, the creating, and the operating of the development system. So this is what I had initially mentioned as all data controllers and processors need to implement the appropriate technical and organizational measures designed to safeguard individual rights and data protection policies. So you're perhaps sitting there wondering, okay, what's all of this? How do I do it? In my opinion, the first way you will go ahead with this is to first take into consideration the data protection principles that have been set out in these particular laws. I'm not going to go through all of them because they all have different requirements. So I'm going to look at the three main ones for this particular talk. So the first principle is lawfulness, fairness, and transparency. So this principle essentially highlights that for every processing activity, there must be a legal reason to do so, and this legal reason has to be commensurate with the rights of the data subject. So let's go back to the initial example that I gave around a fintech that's dealing with healthcare, essentially. So you have the data subject's data here. You have stipulated that you're in the business of offering healthcare services, so maybe you are delivering medical stuff to them. So the legal requirement here is that your need to process their data has to be in line with their protection, with their rights within the Constitution. So that means you can't go ahead and use their delivery address for sending your sales agent to sell pharmaceutical stuff to them. The clause is very clear. You have to be just for delivery and delivery only. Then when we look at the principle of purposeful limitation, this basically highlights the importance of collecting personal data for specific and explicit purpose and not anything outside that particular scope. So if you're in the business of delivering pharmaceutical stuff to your clients, then that's the only reason that their data would be processed. The moment you derogate from it, then you've breached data protection laws. The next principle would be data minimization, which is essentially the principle that restricts the amount of data you have collected for a particular purpose. So what that means is you don't need 5 data points for you to achieve a purpose if you can have 2 of them. What happens is the extra 3 become redundant, and you would have to put in place the technical and organizational measures to ensure that they're properly protected. So you don't need all this data. If you need 2 data points, stick to that. The next point would be the consent of the data subject. So we've seen that there's a lot of processing that's going to happen, and for us to do so, our data subjects have to be aware of why the processing has to happen. So consent is defined as any freely given, specific, informed, and unambiguous indication of the data subject's wishes to agree to their personal data being processed. That's a long definition, and it's not by mistake. There's a reason for it. So when we are looking at the requirements for a valid consent, we notice that it's within the definition of the consent. So first, it has to be freely given. What this means is that the data subject must be in a position where they can reasonably refuse to have their data being processed unless there's a sufficient reason to do so. So for example, if you've told them that in your privacy policy that this data is being used for this, and it's very clear, then there is no chance that the data subject will refuse to have their data processed. However, if there's a lot of mumbo jumbo within that particular privacy policy, they will definitely refuse. The next ground for valid consent would be specific. So this ground suggests that the consent must be requested for a specific purpose and not on a general note. So this goes back to what I've said. The moment you derogate from your explicit purpose of why you're doing ABCD, then you have breached a valid consent. The next is informed. So this ground requires that the consent request must be in a concise, transparent, and easily accessible form and uses plain and clear language. So this goes back to what I mentioned in freely given consent. So if your privacy policy is not clear, then there is no way the data subject has given you valid consent. So it has to be very clear what you're doing throughout the processing and making sure that your data subject is aware of it. The next ground is unambiguous. So this ground requires that the consent must be indicated by a clear acquiescent action of the data subject. Okay, I get acquiescent, big word, no problem. What this means is if there is a pre-checked box on your privacy policy, down there where you say I accept. So if it's pre-checked, that's not valid consent. It has to be done by the data subject themselves. So they have to click on it. So that's the acquiescent, where they have agreed to be bound by it. So when we are looking at consent, to conclude, it just basically means that your legitimate interest to process the data subject's data has to be communicated clearly, and they have to be aware of what's happening. Because one of the requirements under the data protection laws is that data controllers have to have a documented history of the data subject giving their consent. So if you don't have an action to show that they actually accepted, then it would be very hard for you to prove that you are indeed compliant. So then we go to what are data controllers, what are data processors. So this has been defined in the Kenyan space under Section 2 of the Data Protection Act. So a data controller is essentially a corporate body or a public authority that determines the purpose and the means of processing personal data. A data processor, on the other hand, is a corporate body or public authority that processes personal data on behalf of a controller. So what's the difference essentially? The difference is in the element of control. So if you dictate what data, how the data is going to be used, and who is going to be processing it on your behalf, you become a data controller. If your job is just to process the data, it's just in transit within your systems, then that makes you a data processor. So the element of possession is just not enough because both parties are in possession of data. Okay, so now that takes us to the big question. So how do we really comply with data protection laws? So as a developer, you have a website that you have built, or you have a mobile application that you have built. There are certain documents that will illustrate you have understood your requirements under the regulatory space. So for a website, you will have to indicate clearly where the privacy policy of your organization exists, so that the consumer is able to go there without having to look for it. Sometimes you'll see it at the bottom of the pages, sometimes it's on the sides, depending on the designer. And then in order to protect your company assets as well, we have seen the importance of software being protected under intellectual property. So we can't just freely give this software, and we do recognize that. So in order to protect your company assets, you have to put in place something called a terms of use or a terms and conditions document. And on our website, we will also be looking at the cookies policy. So when we are looking at the privacy policy, this is essentially a document that explains what data is being used, how it's being used. Is the company aware of the rights of the data subject, where they can come to you and say, please delete my data? Are they aware of it? It also indicates instances where the company can be changing or amending the privacy policy depending on how far they are able to expand their service. So this document is important because, as I have mentioned, it shows that as an organization you're very transparent in how you do your dealings, and it's also in line with the Data Protection Act, which requires that the data subjects have to be aware of how their data is being processed and by whom. The next document would be the terms of use. So the terms of use is a document between the company and its users. So this is kind of like a contract. Actually, it's not kind of, it is a contract. So what it does is it stipulates the service that is in question, and in order to protect your intellectual property, it goes ahead and states that who owns this particular intellectual property, because you don't want a know-it-all client who can reverse engineer your software. So you have to be very clear from the beginning that, look, this is proprietary information. The moment you reverse engineer, you're in breach of our services and we can sue you for that. It also goes ahead and limits liability. So imagine a scenario where you're very clear in your terms of conditions on how to properly protect your account. So if a client has not put in place the necessary password requirements and there's some kind of breach, then you're able to limit yourself because it's very clear whose fault it is. It's not the system's fault. The weakness is on the client side. So when we are looking at the last document, which is the cookie policy, I mean, we've all seen the memes on social media where people just accept these cookies. We don't know what they are. Honestly, to date, I'm still battling with them. But a cookies policy is a declaration to users on what cookies are active on your website and how this data will be tracking them and for what particular purpose and where this data is being processed. So I don't know if you've been able to if you've seen recently that when you interact with websites that have been built in the EU, there's a huge banner that comes up before you interact with the website that requires you to accept the cookies or customize them however you want. So that's what we call a cookies policy. So a cookie is defined as a text file that includes a unique identifier, an anonymous unique identifier that is sent from the browser of the website to your client's computer, and it's stored there so that the next time they interact with your website, it gives them a better experience. So having understood what is required of you as a developer on a very wide scope, we now go into the emerging issues around content management and what are some of the things that companies are doing that can be construed as being dodgy. So first we will be looking at targeted marketing. So targeted marketing is something that heavily relies on data of the consumer. So for you to be able to sell your product, you must be able to know who your consumer is and what they've given you. So we are starting to see, as data protection practitioners, where marketers would come to us and be like, data protection is more of a hindrance than it is something that is helping the commercial transaction. But we would argue otherwise, because you don't need redundant data. So like I mentioned, if you need 2 data points to get a specific purpose, then you don't need the extra 3, right? So what happens is that you have very accurate and up-to-date information of your customer, which makes it even more valuable than having all this data where you have to figure out what applies to them. So what does that mean for marketers, and can you continue bombarding customers with promotional texts? So noticing that you need consent of the data subject to use your service, and your engineer already knows that they have to ensure that ABCD has been put in place to protect the client's data, then the moment the customer acquiesces to the use of your service, that would be construed as them accepting to use your service, and you can use the data that they have given you to continue giving them the promotional information that you want. However, there has to be a thin line between bombarding your customer with a lot of information. I mean, we have seen the first promotional text. You don't need to send a second one or a third one. So you have to know when you're overdoing it and when you're actually in line with logic and reason. The next thing that we would be considering as an emerging issue is profiling and automated decision making. So we are now seeing companies coming up with profiles of their customers on specific data points that they have received on them, and they're able to know who Lou Jane is, what she likes doing, ABCD, yada, 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 right? And then because of this whole deduction of who I am, it's leading to a very intrusive action on the part of companies that are dealing with my data, where they're able to, I'd be thinking about something and all of a sudden it's popped up on my page. How'd you know that? You have to ensure that as you are building profiles of your customers, you're not building them in an intrusive manner, where you're moving from app to app, because now we've seen that you're adding trackers onto websites, you're adding trackers onto mobile phones and laptops. So you shouldn't be derogating from what is essentially your role in a bid to improve your market space. So as industry players, there has to be an understanding of human rights vis-a-vis your commercial needs. So the moment you build profiles that are intrusive in nature, which would inevitably lead to discrimination, we're seeing this with TikTok developers in Africa, where they are unable to get to a larger audience because of the algorithm, then you've essentially just breached data protection laws. So with that, I hope I have made more sense of what data protection is like, and also what intellectual property rights exists in software and web development. If you have specific questions, you can reach out to me on my LinkedIn, Lujain Abbas. Have a great day.